Ms. Freeman, you disagree with the death penalty, don't you?
Senator, I support the rule of law, and if confirmed, I would apply the
Ms.
rule.
Freeman, that was not the question I asked you. You disagree with the death penalty, don't you?
Senator, if confirmed, I would apply the law regardless of any views that I may or may not have.
So you're hesitating because you're afraid to answer honestly.
Senator, respectfully, my understanding of the code of conduct for United States judges, which applies to judicial nominees, is that I am to refrain from commenting on matters of public policy that may come before me.
Really, this is the same person who submitted a photograph of yourself at a protest at the Philadelphia International Airport, labeled Ariana Freeman, Senator of Philadelphia, cheers and chants with others during a protest to President Donald Trump's executive order banning travel to the U.S. by citizens of Iraq, Iran, Sudan, Libya, Somalia, and Yemen. That's refraining from engaging in public policy?
Senator, I attended that public event in 2017, long before I was a judicial nominee and subject to the code.
Okay, well, the canons don't prohibit you sharing what your views are to this committee, and we have judges appear here all the time. It's not remotely credible that you don't have a view on the death penalty. You've devoted your entire professional career to representing criminals, to representing murderers, to representing rapists, to representing child molesters. You believe the death penalty is wrong. You have been a zealot against the death penalty. Is that true or false?
Senator, I have spent 12 and a half years fulfilling my duty to zealously advocate for the interests of my client, regardless of the sentence. Some of those sentences were death sentences. For the past 8 or so years, I have worked on non-capital cases.
Okay, well, I'll tell you, let's take the case that the Pennsylvania Supreme Court talked about, and Senator Hawley discussed this some. Terrence Williams, one of your clients, had a long list of violent crimes, including armed robbery and another murder, just months before he killed Mr. Amos Norwood. Mr. Williams had separately been convicted of murdering a different victim by stabbing him 20 times in the head, the back, the chest, clean through his neck, before then trying to burn his body. Apparently, this method of murder was one Mr. Williams was fond of, because his second victim, Amos Norwood, he blackmailed him to meet him in a cemetery, where Williams beat Norwood with a tire iron until he died. And then the next night, Williams returned to burn the victim's body. Terrence Williams is a bad guy. When you're faced with a repeat murderer about whom there are no serious questions of guilt, nobody doubts that this guy is a serial murderer. Your choice, you don't feel sympathy for the victims, you don't stand with the victims. Your choice, you've spent your life trying to save that murderer. And listen, here's what the Chief Justice of the Pennsylvania Supreme Court said about your office. Because you keep saying zealously represent, and you're right, everyone is entitled to a defense. But it's not the job of a lawyer to be obstructionist. Is it the job of a lawyer to be obstructionist?
No, Senator.
Well, the Chief Justice of the Pennsylvania Supreme Court describes your office, says the extraordinary shadow capacity of the FCDO, your office, and its demonstrated tactics give me additional pause. Here the Chief Justice continues. Almost invariably without legitimate court appointment, without any Pennsylvania authorities' approval or role of oversight, this private group of federal lawyers pursuing an obstructionist anti-death penalty agenda have essentially anointed themselves a statewide de facto capital defender's office. Common tactics of the FCDO include multiple attempts to delay and obstruct cases, as well as attempts to unsettle and undermine Pennsylvania law. Do you think it's extraordinary that the Chief Justice of the Pennsylvania Supreme Court accuses you and your office of being zealots engaged in an obstructionist anti-death penalty agenda?
I'm not aware of how often something like that occurs, Senator.
Well, I'll tell you, I've practiced law a lot of years. This is extraordinary. And you know, Senator Booker asked, why do you choose to do this? I actually think Senator Booker's question was a great question. You said you care about public service. He rightly pointed out, well, you could have been a prosecutor. Many of us on both sides of the aisle have been prosecutors. You didn't want to be a prosecutor. You wanted to stand with the criminals because, as the Chief Justice has said, your office is engaged in a zealotry, in an agenda against the death penalty, game playing. And, you know, Senator Booker said, well, it's bad for your career to be a public defender. That actually is not the case. If you look at Joe Biden, last night Joe Biden said we shouldn't abolish the police, and all the Democrats stood and applauded. But interestingly enough, Joe Biden keeps nominating some of the leading advocates for abolishing the police to senior positions in the Department of Justice, and every Senate Democrat confirms them. Joe Biden keeps nominating DAs who refuse to prosecute violent crime to be federal prosecutors, and every Democrat votes to confirm them. And Ms. Freeman, you should feel comfortable. No matter how much your office has been called out for being anti-death penalty zealots, siding with capital murderers and ignoring the law, every Democrat on this committee is going to vote to confirm you. But I will tell you, this is a three-pronged strategy from the Democrats to abolish the police. Putting prosecutors in place who don't follow the law, putting judges in place who don't follow the law. And there's a reason we see crime rates and murder rates and carjacking rates skyrocketing across this country. Because the job of a judge is to follow the law, not to be a zealot pursuing a political agenda.
Senator's time has expired. I want to thank this panel for appearing before the Senate Judiciary Committee today. There may be written questions coming your way, which we hope you can respond to in a timely manner.
He committed a burglary. That next year, he committed armed robbery. He broke into the home of an elderly couple on Christmas Eve, I believe, woke them up by pressing a gun to their heads, fired that gun to threaten them into submission. Fortunately, nobody died in that incident, but as I'm sure you remember, others were not so fortunate. In 1984, while he was on release for that armed robbery, he murdered Herbert Hamilton by bludgeoning him with a bat and stabbing him 20 times with a 10-inch butcher's knife, and he then tried to set the body on fire. That is not, however, the murder for which he received the death penalty. 6 months later, he brutally murdered Amos Norwood. He drove this individual, the victim, to a cemetery, made him lie down near a tombstone, bludgeoned Mr. Norwood with a socket wrench and then a tire iron. Before using Mr. Norwood's credit cards to go on a shopping spree, he returned the next day and set Mr. Norwood's body on fire. The court record reflects that one of the motivations apparently for the crime was that Mr. Norwood was gay, and I haven't even listed all of his crimes. He was convicted by a jury of his peers. He was found to be eligible for the death penalty. He was sentenced to death, and then you intervened. And you argued for years that Pennsylvania law shouldn't be carried out, that he shouldn't be actually executed according to the laws of Pennsylvania. Numerous courts rejected the claims that you raised on behalf of this individual. Do you regret trying to prevent this individual who committed these heinous crimes from having justice served upon him?
Senator Hawley, my office was appointed to represent Mr. Williams for his post-conviction proceedings, and we did so as was our duty. And ultimately, Mr. Williams actually prevailed both in the United States Supreme Court as well as in the Pennsylvania courts because of unlawfulness that took place during the course of his conviction. And my colleagues and I pursued those available arguments under the law, and we did prevail.
Well, the death sentence was not carried out because of a technicality involving a justice on the Supreme Court, the Pennsylvania Supreme Court, who refused to recuse himself 30 years later. It has nothing to do with the facts of the case. So what I hear you saying is you stand by the arguments you made that this individual should not be executed, that this sort of person, under Pennsylvania law, he was convicted, he was sentenced to death, and you argued for years long before the recusal issue and having nothing to do with that, you argued that on the facts of the case, this individual shouldn't be executed despite the fact it was Pennsylvania law. I take it from that you're opposed to the death penalty as a matter of principle.
Thank you, Senator. My office again was appointed to pursue Mr. Williams' constitutional rights, and we raised a number of constitutional challenges, some of which actually, in addition to the recusal issues, did ultimately prevail. There was a violation of due process that was found.
But you say that, Ms. Freeman, but you get to choose as an advocate. I've been an attorney. I am an attorney now, former prosecutor, the attorney general of my state. You get to choose the arguments that you make. You get to choose how you defend your client. You chose to defend this individual and to seek to have the sentence that he was given, to have it prevented from being carried out upon him. And I'm just, in light of these facts, I'm amazed by it. I'm also amazed at what the Pennsylvania Supreme Court Justice had to say about your office, which you've now twice referenced. He said, and this was in one of the cases in which you were involved, this is the Chief Justice of the Pennsylvania Supreme Court. He says it has only recently emerged just how pervasive a presence your office, the Federal Community Defender's Office, has made itself in Pennsylvania capital cases, almost invariably without legitimate court appointment and without any Pennsylvania authorities' approval or role of oversight. This private group of federal lawyers pursuing an obstructionist anti-death penalty agenda have essentially anointed themselves as statewide de facto capital defender's office. Common tactics of your office include multiple attempts to delay and obstruct cases like Mr. Williams, as well as attempts to unsettle and undermine Pennsylvania law. That's the Chief Justice of the Pennsylvania Supreme Court. Those are very serious allegations from the head of the court. If this is what your office was doing while you were there in these kind of cases involving people like Mr. Williams, how can we have any confidence that you will follow the law as a federal officer yourself?
I see that the time has expired. May I respond? Thank you, Senator Hawley. I understand that that was the position of the former Chief Justice of the Pennsylvania Supreme Court. I can tell you that I represent individuals when I have been directed to do so by the court, and I fulfill my duty to zealously advocate for those individuals.
So he was wrong. The Chief Justice was wrong. He misstated the facts or was incorrect here.
Senator, I'm not sure exactly which cases he was referring to in that.
This is a concurring opinion of the Terrence Williams case.
Okay, I see. That was his opinion.
My time has expired, Mr. Chairman, and I'll have some additional questions for you, Mr. Freeman. All I can say is these allegations and this record, frankly, is extremely, extremely.
Thank you, Mr. Chairman. I agree that it's very important for everyone to have zealous advocates defending them, even when, especially when, you've got an unpopular client who's been accused of a heinous offense. Everyone needs zealous representation. I think there is a line that has to be drawn, though, between zealous representation and arguing things that are indefensible. Now, when Senator Hawley read the quote from you a few moments ago, the quote from Chief Justice Castile from the Pennsylvania Supreme Court, these are pretty legitimate concerns. It's a rare thing in my experience. And I've worked in civil litigation, I've been a prosecutor, and I've also been involved in criminal defense. It's a very rare thing for a judge to use words like describing a particular office as engaging in repeated attempts to unsettle and undermine the law. What I was perhaps even more troubled by was your response. If I understood you correctly, you said that was just his opinion. There is a difference between an individual expressing an opinion and a judge before whom you're appearing making these arguments. These are arguments that a judge makes when imposing sanctions. And ordinarily, when I see a judge express things like this, it's a very rare moment, but it's almost always accompanying a finding that it's time to impose sanctions. So do you want to explain what you meant by when you said that was just his opinion?
Senator, I agree that the quote that Senator Hawley read was from that concurring opinion. I can't tell you what the foundation of that was. It was about my office, that Justice's opinion of my office writ large. I'm not.
But he wasn't making it in the abstract, was he? Not just in the abstract. He was making it in a particular context.
I understand from Senator Hawley that he was making it in the context of a concurring opinion in that appeal.
In that case in which you were involved as a lawyer.
That's correct, Senator Lee. I do not recall being involved in that particular appeal, however.
Now, Judge Castile cited two other cases where these tactics were apparently used by your office, and I'd like to know whether you were involved in either of those. Were you involved in Commonwealth versus Porter or Commonwealth versus Abdul Salam?
I was not.
And even if you weren't involved in either of those cases, you have made statements that appear to appeal to some of the same tactics. In a presentation you gave entitled, quote, Appeal to the Equities, this instruction was given, quote, argue anything and everything you can think of to get your client tolling, because if his claims are untimely, they'll be dead before they even begin. Do you want to clarify what you meant by that statement?
Senator, I don't recall that presentation or that statement.
Okay. Happy to follow up on this in writing and supply you with additional background if you'd like. Now, I want to follow up on another line of questions you got from Senator Kennedy. Senator Kennedy was asking you how you felt about someone having a policy of just not prosecuting certain crimes, certain entire categories of criminal offenses in pursuit of a social justice objective. You didn't answer that. I'm still trying to understand why. I understand that prosecutorial discretion is a thing. It's an important thing. It's a thing that represents the fact that in any prosecutor's office, there are finite resources. You can't go after everything all the time, so you have to go after the cases that you can handle and handle that effectively. But that very same purpose is not only not served, it's actively undermined if a prosecutor says, I will not be prosecuting offenses A through G. I just won't be prosecuting them. Your refusal to answer that question and provide an answer like that is troubling to me. Do you want to explain why you're not willing to answer that one?
Senator, I recognize that the decisions that prosecutors make are complex policy decisions. I do not have all of the information relevant to those decisions, and I would rely on prosecutors to make appropriate decisions about the use of their prosecutorial discretion, and any legal challenges to that I would certainly review. But again, I do not feel informed enough to have a view on that question.
Yeah, but typically, and in fact, I could modify that by saying universally, legal challenges to a prosecutor's refusal to bring a case aren't really a thing. It's not how the system works. It's not. You don't bring the case about the dog that didn't bark, and you also don't bring the case against the prosecutor who didn't bring a case. It doesn't mean that there aren't important questions of discretion, and it isn't prosecutorial discretion when you notify people in advance before they've even committed the crime that those crimes won't be prosecuted. And so of all the questions you've been asked today, this one strikes me as one that should have been the easiest to answer, and that's why I'm so perplexed by it. I'm not sure that I've encountered another nominee before this committee who has been unwilling to answer a question like that. It seems like the easiest question of all to say, yeah, a prosecutor should not categorically announce that he or she will never prosecute an offense in this category on the basis of a social justice concern. Can you help me understand that?
Yes, Senator. And in my career as an advocate, I have focused on specific challenges in specific cases. And if confirmed, I would focus on specific challenges in specific cases. And I am required as a judicial nominee to refrain from comment on matters of public policy, such as the one that you've raised. I understand those are issues of grave importance, and I defer to policymakers to make those decisions.
Hiding behind the cannons isn't appropriate here. Isn't requiring you to comment on a particular case. I have grave concerns with your refusal to answer that. Thank you.
Thank you, Senator Lee, and Senator Ossoff is next.
Thank you, Mr. Chairman, and congratulations to you both